5 seconds to go. Start. Is the need for sanction to be considered as soon as the complaint is lodged and on the allegations therein contained? At first sight, it seems as though there is some support for this view in Hori Ram case 1939. Suleiman Judge says that as the prohibition is against the institution itself, its applicability must be judged in the first instance at the earliest stage of institution. Viradacharya Judge also states that the question must be determined with reference to the nature of the allegations made against the public servant in the criminal proceeding. But a careful perusal of the later parts of their judgments shows that they did not intend to lay down any such proposition. Suleiman Judge refers to the prosecution case as disclosed by the complaint or the police report, and he winds up the discussion in these words: of course, if the case as put forward fails or the defense establishes that the act purported to be done is in execution of duty, the proceedings will have to be dropped and the complaint dismissed on that ground. The other learned judge also states at page 185: at this stage, we have only to see whether the case alleged against the appellant or sought to be proved against him relates to acts done or purporting to be done by him in the execution of his duty. It must be so. The question may arise at any stage of the proceedings. The complaint may not disclose that the act constituting the offence was done or purported to be done in the discharge of official duty, but facts subsequently coming to light on a police or judicial inquiry or even in the course of the prosecution evidence at the trial may establish the necessity for sanction. Whether sanction is necessary or not may have to be determined from stage to stage. The necessity may reveal itself in the course of the progress of the case. In Pukhraj versus State of Rajasthan and another reported in 1973 to SCC 701, the second respondent was alleged to have abused and kicked his clerk who was his subordinate and was charged under sections 323 and 504 IPC. The court opined that such an act cannot be said to be in the purported exercise of his duty and held that sanction under section 197 CRPC was not necessary. However, it was also observed that the necessity of sanction may reveal itself in the course of progress of the case and that it would be open to the accused to place materials on record during the trial for showing that his duty was and also that the acts complained of were so interrelated to his duty that protection under section 197 CRPC must be granted to him. It was observed as follows: we must also make it clear that this is not the end of the matter. As was pointed out in Sarju Prasad versus King Emperor, referring to the observations of Suleiman Judge in Hori Ram Singh case, the mere fact that the accused proposes to raise a defense of the act having purported to be done in execution of duty would not in itself be sufficient to justify the case being thrown out for want of sanction. At this stage, we have only to see whether the acts alleged against the second respondent can be said to be in purported execution of his duty. But facts subsequently coming to light during the course of the judicial inquiry or during the course of prosecution evidence at the trial may establish the necessity for sanction. Whether sanction is necessary or not may have to depend from stage to stage. The necessity may reveal itself in the course of the progress of the case. In Bhagwan Prasad Srivastava versus N.P. Mishra, also it was pointed out that it would be open to the appellant, the second respondent in this case, to place the material on record during the course of the trial for showing what his duty was, and also that the acts complained of were so interrelated with his official duty so as to attract the protection afforded by Section 197 CRPC. In B. Saha Supra, the court went on to observe that they have no quarrel with the proposition that the question of sanction under Section 197 CRPC can be raised and considered at any stage of the proceedings. Moreover, it was also stated that in considering the question whether or not sanction for prosecution was required, it is not necessary for the court to confine itself to the allegations in the complaint, and it can take into account all the material on record at the time when the question is raised and falls for consideration. Similar to the rationale adopted in B. Saha Supra, this court in State of Bihar versus Kamala Prasad Singh and others reported in 1998 5 SCC 690 also reaffirmed that while determining whether the public servant was acting in the discharge of his official duty, the court must consider not only the allegations made in the complaint but also other materials available on record. In Bakshish Singh Barad versus Gurmej Kaur and another, reported in 1987 for SCC 663, the petitioner police officer along with 14 other persons was charged under sections 148, 149, 302, 323 and 325 IPC for allegedly causing hurt to the complainant and also causing the death of her son. This court had emphasized that a balance has to be struck between protecting public servants from being harassed in criminal prosecutions and protecting the rights of the citizens against unlawful acts of public servants. This must be done by examining as to what extent and how far is a public servant working in the discharge or purported discharge of his duties and whether the public servant had exceeded his limit. Having said so, it was observed that criminal trials must also not be stayed in all cases at the preliminary stage because that will cause great damage to the evidence. The relevant observations are reproduced herein below. In the instant case, it is alleged that grievous injuries were inflicted upon the complainant, and as a result of injuries, one of the alleged accused had died. The question is, while investigating and performing his duties as a police officer, was it necessary for the petitioner to conduct himself in such a manner which would result in such consequences? It is necessary to protect the public servants in the discharge of their duties. They must be made immune from being harassed in criminal proceedings and prosecution. That is the rationale behind Section 196 and Section 197 of the CRPC. But it is equally important to emphasize that rights of the citizens should be protected and no excesses should be permitted. Encounter death has become too common. In the facts and circumstances of each case, protection of public officers and public servants functioning in discharge of official duties and protection of private citizens have to be balanced by finding out as to what extent and how far is a public servant working. Stop.